All right. I think we have 1:30. I think we have everyone here. I'll get started. Please sign into the attendance. I will take Heather's puppy off spotlight. Any questions before we get started? I will do a review in a minute, but any questions in general before we get started? I do not see any hands. All right. I'd like to begin by reviewing some of the topics from last week that I think gave people some confusion. I have the class notes. I flagged them so I wouldn't forget what you want to talk about. A number of students asked me in the minute poll, what is the current status of Buckley? It's good law. Buckley held that Congress can impose restrictions on what's called hard cash, the contribution limits to the candidate, right? That's still good law. Buckley also held that limitations on independent expenditures were unconstitutional. That's still good law. The third relevant precedent is Citizens United that we studied. That is also good law. Under Citizens United, the government can't ban spending on what's called electioneering or advertising within 60 days for the election out of a fear that it might distort the political process. Right? So the anti-corruption rationale from Buckley is still good law. And the anti-distortion rationale was rejected in Citizens United. So we have this almost 30-something year gap between these cases, and then you're going to have to reconcile them in any given case. Yeah, Gavin, I see your hands up.
Yeah, so just in clarifying that, so I get they had their specific limits on contributions and expenditures, and it says, so the restrictions on independent expenditures are unconstitutional, but it also talks about expenditures in regards to political parties.
Yeah, those are allowed.
Yeah, so that was my question. Is it like an expenditure from a political party or an expenditure to a political party?
Right. It's not limiting what the party can spend on once they have the money. It's limitations of giving to the political party.
Wouldn't that then be a contribution technically?
No, a contribution is only to a candidate, not to the party.
Okay, so that gets into the actual definition of it.
Right.
Okay.
The contribution is to the candidate specifically. Now, of course, if you give a donation to the Republican National Committee or the Democratic National Committee or the Democratic Senatorial Campaign Committee, they can then in turn run ads supporting different candidates. But that's not a contribution to the candidate himself.
Okay, no, yeah, it was just a clarification of like they're giving money to someone, so wouldn't that be a contribution? But no, that clarifies.
I mean, look, I made this point last class. I'll make it again. This Buckley line merely allows people to get creative with how they give money, right? If you're not giving it to one bucket, you're giving it to another bucket, which will serve very similar purposes. So in my mind, this is all just, it was an artificial distinction. Perhaps the court had upheld the expenditure ban in Buckley, then we wouldn't have all this stuff. But that's where we are today. Okay. A couple students asked me about, do you need to know the views of different justices at different times? So, if you're asking a question in the 1970s, Buckley would be the rule. If you're asking a question in the mid-2000s, you would follow McConnell. If you're asking a question today, it's Citizens United. And the short answer is yes, you do need to know them. The way I test in common law, which many of you are in my class, is I give you a period of time saying the year is 2005 or the year is 1975, whatever it is, and you are limiting yourself to the precedents that existed at that time. It's perhaps different than you studied common law before, but I test this way for a very specific reason. I want to see that you can show how the law developed, not just where it is today, how the doctrine existed, right? We had McConnell for about 4 or 5 years. That was the law, right? I mean, actually, that's 7 years, right? That was the law. And you need to know what the law is during that period. I'm still figuring out the specifics for your exam. Given that this is a 2-hour class, I think I'm allowed to give a 2-hour exam, which would probably mean one question, which is what I'm leaning towards. So I usually give 2 questions in 3 hours. I think what I would probably do is give a single question in 2 hours. That means you'd have more time, which I suppose be helpful. But it's tricky, right? I have to balance out how I want to handle it. I haven't decided. I'm still thinking it through. Macy said it makes you nervous to have one question. Why does it make you nervous?
Because what if you don't know the answer to the one question?
Well, it's one question with 5 subparts, so it's not a single question, right?
Sure. Yeah. But like if you have 2 questions, you can at least like divvy up your balance of knowledge, I guess. I don't know.
Yeah, but the upshot is, though, you would have 2 hours for a single question rather than 90 minutes for each for 2 questions. In other words, you have more time. Right. Yeah. There's a lot in the question. In other words, I would give you more time for fewer questions. The word limit would be the same. All right, I'm seeing mixed reviews. People who want to talk later, you can. I'm still giving it some thought. It's also the fact that I have 90 of you, which is a very, very, very large section. And as you know, the school is becoming very strict on when grades are due. So given 90 students all essay, I'm leaning towards one that would have more time. So you have 2 hours for a single question with 5 subparts. I haven't decided yet, but I want to float that with you all. People are saying in the comments, 1 question, not that bad. Okay. People are happy. I mean, I haven't decided yet. I'm not, I'm not committing to anything, but that's what I'm leaning towards. Because again, the school's becoming, for good reason, they want us to submit our grades more quickly, which I think makes a lot of sense. But if you want grades submitted quickly for your law review and summer employment and everything else, 1 question is quicker to grade for 90 people than 2. Word limit would be the same, though. It'd still be 1,000 words. So the word limit would be the same. All right. Macy, are you sure? I haven't decided yet. But the word limit's fixed. That's not moving. That I'm not budging on. I like the word limit. All right. Other questions before we get started? Nancy, are you giving thumbs up? Okay, thank you.
No, Andre, I can't. I don't know why my thumbs up and I can't get it down. Okay, there. Thank you.
Okay, thank you. I'm gonna just unspotlight you now. Okay, this is the Title IX waiting to happen. Okay. Anything else? All right. Let's go on to today's material, please. Presley asked, we have more practice exams. I'll see what I can do. I've only taught this class once before, so I have one other exam, and we don't really have time for a midterm. And in fact, I don't think a midterm is useful for an upper level class like this. I like midterms for first semester, second semester, maybe third. You're all in your 4th, 5th, or 6th semesters. I think a midterm is not the best use of our time, especially since we're so rushed. But I'll see what I can do, Presley. I'll give it some thought. Let's go on to today's material. All right. So we've discussed before that there's certain categories of speech that are not protected. We talked about fighting words. We talked about obscenity. One example we didn't talk about is fraud, which should be something you're familiar with from contracts, right? If I lie to you and I make you a fraudulent contract and you sue me for damages, I can't raise the First Amendment as a defense. I don't have the right to commit fraud. Another category of speech that's sort of outside the First Amendment is defamation or libel or slander, whatever you want to call it. I know in torts they care of the difference. I don't care of the difference. It's not important. It's all defamation to me, right? Is defamation subject to the First Amendment? So if I go up and I go to a person on the street and say, you know what, you are a crook, you are a murderer, right? I'm speaking. I'm engaging in speech. It's my opinion. Well, it's not just your opinion. It's a false statement about a person that can tend to injure their reputation, and that's a black letter element of defamation. So you're familiar with the concept of defamation, and usually the First Amendment's not a problem. But what if instead of criticizing a random person on the street, we're criticizing a person in government, some sort of public official who's responsible for administering the law? Does the analysis change? In other words, why would we create a First Amendment defense for defamation? And I think the answer has to be found at the very first day of class. We talked about the Sedition Act, right? The very first day of class, we talked about the Sedition Act. The government passed a law that allowed people to be punished for criticizing the government. Now, what happens if your criticism of the government was true, right? What if you said that, John Adams was a corrupt administration and it happened to be true? You could still be punished for that statement under the law. All right. Now, let me twist the hypothetical. What if you make a statement of opinion that it isn't really clear if it's true or not, right? In politics, the truth is often very gray, right? It's not black or white, it's sort of in the middle. What if you make a statement about a politician that's critical of them that you think is true, but it turns out you're mistaken? Or maybe a court thinks you're mistaken. What would it mean for that public official to then be able to sue you for libel? It's silencing speech. So our first case today, which I think you all studied in torts long ago, our first case today explores that tension, right? The tension between having the space to criticize the government without running afoul of defamation laws. All right, any questions so far? Who's next? Where am I up to?
I think you're up to me.
Baker, thank you so much. Oh my God, I'm only up to H. This class will take forever to get down to the last letter. It's a short class. All right. Baker, you want to give me the facts, please, in our first case, New York Times against Sullivan?
Yeah, so this was a case where the New York Times published this ad, and the ad was created by these, I guess, activists from Alabama, and it kind of it was kind of an ad asking for donations, really, but they outlined some things that happened to Black protesters in the South, and there was one where the police padlocked the students from getting into the cafeteria to kind of starve them. And then there was another one where they said that the police had arrested MLK 7 times when I think he was actually only arrested 3 times. And so the commissioner who oversees the police in Montgomery sued the New York Times because he said that people reading that ad could think that they were talking about him in the ad, that he was the one who, I guess, okayed for the police to do those things. So he sued for libel.
Very good. Thank you, Baker. Appreciate that. All right. So we have a case, and I want to just break down a few elements of this first. First off, we're in 1964 in Alabama, right? This was a very unique period in American history. This was like the time when the Civil Rights Revolution was raring. Congress had just enacted the Civil Rights Act of 1964. If you remember the cases of Katzenbach and McClung and Heart of Atlanta Motel, this was a sweeping federal legislation that prohibited discrimination nationwide. We're about a decade removed from Brown versus Board of Education. School integration is not going so well in these areas. Segregation is rampant. And you have a movement in the South to draw attention to the oppression of the Black community there. Martin Luther King had been arrested a number of times for merely marching in public. The states were using their police powers to try to shut down these protests against civil rights abuses. So you have a group. You have a civil rights group that's trying to raise money. Nothing wrong with that. And they put an advertisement in the New York Times, right? There was no Facebook, there was no Twitter back then. If you want to reach a large number of people back in the 60s, you put an ad in the New York Times, right? That's what you do. And this is a committee to defend MLK. They put a full page commercial in the Times. Now, that was Baker. Tori, you here?
Yeah.
Hi, Tori. Let me ask you a question, please. So, we did Citizens United last week. We read that case, just a couple days ago. And one of the issues in the dissent from Justice Stevens was that corporations should not have First Amendment rights. Okay. Was this commercial, was this some sort of book? Was it a movie? What exactly was this speech? What was it trying to accomplish?
In New York, it was, weren't they trying to raise money or something?
Yeah. And is a committee to defend MLK a person? It's a stupid question, but just yeah.
No.
No, is the New York Times a person?
No.
What are these entities? If you had,
Not like a corporation.
The corporations, yeah. And the New York Times is a for-profit corporation. They made, they still make, they made some money. They were selling these commercials. Let me ask you this question, Tori. Why should a corporation have the right to run, constitutional right to run advertisements? This was not an article. This was not editorial. It was a commercial, just raising money. Why should the First Amendment protect this right?
Because I think they still have, the First Amendment was created for people to have the right to say things and
raise money.
I think so.
Do you think Justice Stevens? Do you think there's any tension with Justice Stevens' dissent in this aspect of the case?
Sorry, what's your question?
Justice Stevens in Citizens United said that corporations should not have First Amendment rights. How do you reconcile, or can you reconcile that with Sullivan?
I mean, the Times is a corporation.
It is.
So I guess with the dissent, then they aren't persons, so they wouldn't be protected.
Yeah. Thanks, Tori. I don't want to belabor this point too much, but it seems entirely uncontroversial here that the corporation gets full free speech protections. Now, maybe you could argue that the newspaper is the press. Some people sometimes flag that, but this is a commercial. This was not like an editorial or it was a fundraising thing, right? It's a commercial. Later this semester, we'll do something called commercial speech. It's another area of the law where the courts have said for so-called commercial speech, there's less free speech protections. That doctrine came much later than Sullivan. So as far as the court's concerned here, the corporation gets whatever rights that a free person would. Okay. Now, Samia, are you here?
Yes.
Okay, let me ask you a question, Samia. Why did Sullivan sue the New York Times? Why didn't Sullivan sue the committee to defend MLK? They're the ones who wrote the commercial.
I guess because the New York Times has more control over what's published and they have deeper pockets.
Oh, okay, yeah, there we go. Deeper pockets. That's what I was looking for. Very good. We all know about the deep pockets theory of law, right? You sue whoever has the most money. But I think there's another reason, to me, I want to get at with you, if I can. Do you think that the commissioner of Alabama really cared what the New York Times thought about him? What the people who read the New York Times thought about him? Do you think this case was actually about defending his damage and New York liberal circles? Was that what this case was about?
No, I think he just didn't want the activists to be able to freely like protest and
Good.
say what they wanted.
Let's just assume, Samia, let me ask you one more question. Let's say the court came out the other way and ruled against the New York Times. What would that do for future civil rights groups and fundraising?
You wouldn't be able to peacefully protest, and it would be like the protests that happened.
Well, it's not just the protest, but what would it do to fundraising efforts? That's my question.
I guess you wouldn't be able to raise money for these activists and the organizations to like help.
Why couldn't you raise the money? Couldn't they just put in truthful statements in the newspaper?
Because I guess it would kind of go into the free speech. Like they wouldn't be able to freely advertise, or like raise money and ask.
All they have to make is truthful statements. What's the problem? Why can't they just put a commercial just truthful statements? They're not defamatory.
I mean, I guess maybe they could just ask for donations, but they wouldn't be able to make any additional statements.
Okay, now we're getting closer. Okay, so Louis, why can't? Let's say the court ruled for the New York ruled for Sullivan here. Why couldn't this group, Committee to Defend MLK, just put in truthful statements? They can't get sued for truthful statements. Well, what's the problem? Why can't they just make truthful statements?
I don't know. I mean, I feel like they could have made truthful statements, but maybe it's not going to get their point across as much.
Oh, okay. Now we're getting closer. Why do you think? What do you mean get their point across? I think you're getting closer to what I'm looking for.
They were definitely going for shock value here. They wanted
shock value. Oh man! So give me more. Tell me what do you mean shock value?
Just they wanted people like in the North that didn't live in the South to know the atrocities that were going on. So if you blow those out, not blow them out of proportion, but if you make them bigger, people will respond. And
so if you're just a very sterile, fact-bound description, would that raise a lot of money and get a lot of people interested?
Probably not. It'd be a boring article.
That's it. All right. There's also another factor which I'll help you guys with. Fact checking is expensive, right? When you run a commercial and you actually want to fact check, it takes time and effort. And this group was in desperate need for money. They wanted to run this commercial very quickly. Maybe they didn't have time. There was no Google back then. You couldn't say, Siri, how many times was MLK arrested, right? That wasn't a thing in the 60s. You couldn't do that, right? Maybe they just made a mistake. Maybe they weren't certain, right? Maybe the New York Times could have hired more people to fact check their commercials, but that's expensive, right? The newspaper doesn't have the means to fact check every commercial. So I think we can say as a practical matter, the decision of the court here reflected reality. If the newspaper, the New York Times, could be sued for defamation, it would decrease the ability of these groups to fundraise. And I think you need to keep that in the back of your mind, right? What the court does here is a radical change for defamation law. Today, we're used to it, right? This has been the law for 50 years, so it's like whatever. But at the time, this was radical, right? Avery, are you here?
Yes, I'm here.
Avery, what is the change that the majority made to defamation law? What change did they make?
In this case, well, I believe they said you have to have, are you talking about when they said you have to have the actual malice standard?
Mm-hmm.
So basically, if you know there's a falsehood being stated and you publish it anyway, then that is actual malice. But if not, then it could be considered negligence. Okay.
Thank you so much, Avery. Excellent. All right. So the court basically creates a distinction for defamation law. If you're criticizing a non-public figure, you follow the traditional standard, right? Standard of negligence, right? If you make a false statement about someone that injures their reputation, even if it's not intentional, you're on the hook for defamation, right? But for a public figure, there is a higher burden. The public figure who sues must show that there was intent, or at least recklessness, right? What's that standard? You have to show that the defamatory statement was made with actual malice. Actual malice. Malice means like an ill will, or malice of forethought, if you remember that from Crim. It's somewhere buried in the back of your recesses of your mind. Actual malice. How does the court define actual malice? It's either a knowing or reckless standard. You have to know your statement was false, or you were reckless. You had reckless disregard about whether it was false or not. Okay? So let's take the easy example with the MLK arrest, right? They say he was arrested, was it 7 times? He was really arrested 4 times, whatever it was, right? That's a reasonable mistake, right? Again, there was no Google. There was no easy way to figure this out. I mean, maybe they could have called him and asked, I suppose, but you're looking at many different police departments. So if I said 7 instead of 4, is that a reasonable mistake? Yeah. Was I negligent? Probably. Under the traditional standard, that was a negligent error. I'd be looking for defamation. Very stringent. But the court says public figures, we have to be more permissive. You have to give people the space, the latitude, the discretion to criticize the government officials. And we can make statements that are perhaps not true, but not intentionally false, right? I didn't intentionally lie about the number of arrests there were. I didn't intentionally lie about, I didn't have a reckless disregard of truth. I just made a mistake. Now, the MLK statement is sort of a bad example because it has nothing to do with Mr. Sullivan, right? He didn't arrest King 7 times, 4 times, whatever it was. The other example is probably better. Did the government padlock the cafeteria? All right, that's actually what happened in Alabama. Now, let's just think about this for a minute. That's a pretty big deal, right? To padlock students into a dining hall. I mean, that's to starve them to submission, right? That's going to get some eyeballs. It never happened. Was that recklessly false? Maybe. It was perhaps not intentionally, but that's something you can check on pretty easily. Like, did they try to starve students to death by locking them in? Oh, no, that didn't happen. So it's not even clear to me that this case meets the standard, right? I think there might have been actual malice under the case. But what I'm trying to get at is this is a very permissive standard. You really have to know your statement was false, right? It's not enough to just, you probably should have known and you were reckless. This is a standard that's meant to protect speech in a very broad fashion. I see it in a similar light as Brandenburg v. Ohio, which ironically was in favor of the Klansmen, right? This is in favor of the civil rights people. Brandenburg was for the Klansmen. But Brandenburg had this very tight definition of imminence that unless it's exactly at this moment, right, you're not going to be on the hook. And I see both Brandenburg and Sullivan as on the same wavelength. It's designed to protect speech as much as possible. Right, you've adopted a standard where you have a public official. It's going to be very hard for them to sue for defamation. It's almost impossible. It's very rare that an American court will allow a public official to sue for defamation. It's rare. I mean, there are going to be some examples where the statement was ridiculously intentionally false, and the people know it. They were knowingly lying, but it's rare. In other countries, in Europe, for example, defamation awards are much simpler, right? The British press in particular are always getting in trouble for defamation, especially with the royal family and the prince and princess and all these other people, right? There's no princess, there's a duchess, or whatever. We fought a war over that. Not interested. But Harry just won a case. They have these cases in the UK all the time. Yeah, Joe, go ahead. I can't hear you, Joe. I'm sorry. I still can't hear you. Maybe headphones plugged in. Don't hear it. I'm sorry.
I can't hear you.
Ah, now I hear you. I can hear you now.
No, I said who fact checked these claims of being false at the time?
I'm sorry. Are you talking the court's opinion?
No, like, so to say that MLK wasn't arrested 7 times or that the students weren't locked in, like who fact checked these things?
It's a good question. I'm not sure. I'd have to check the record.
Because in the Alabama South back then, you know, the news or it was what they said it was. Like my mother went to an HBCU. And probably around that time, back in the day, and she's got stories of the cafeteria and a lot of her friends at the same time feeding them something called saltpeter. And you can Google it. Saltpeter was a chemical that they put in African-American kids' food to curb their sexual urges. But if you ask, like, you know, people that ran the Texas A&M school system, which I've run into a few of them, they swear to God that didn't happen. I've got firsthand accounts that it did. You know what I mean?
Well, I see what you're saying. It's a good question. I don't know the answer.
It wouldn't shock me.
I tend to think so. I mean, if you're the lawyer for the New York Times, if there was some evidence that these statements were true, you probably would have brought it forward. But the lawyer conceded that these statements were false. So I think if you're arguing with the Supreme Court, and by the way, Herbert Wexler argued this case. He's one of the premier First Amendment lawyers in the country. If there was some evidence that there was truth, that maybe it wasn't padlocking, maybe it was something similar, they probably would have brought it forward. But I've not seen that evidence, so I don't know.
Yeah.
But I hear your point.
It wouldn't shock me if MLK was arrested 3 more times, but it was just off the books. Like the cops showed up at his house, you know, put him in a paddy wagon, but nobody ever recorded it. You know what I mean? Like that stuff.
Entirely possible. And in fact, you know, let me just take your point, Joe. One of the reasons why the actual malice standard exists was to deal with these sort of fuzzy claims where it's not exactly sure what happened, where he said this and she said that, and maybe the press was a little bit biased, right? So the actual malice standard accounts for these sorts of situations where maybe what was in the newspaper wasn't the truth, right? It gives some latitude to speakers to perhaps write, well, here's what my cousin told me. This is different with the newspaper. My cousin told me this, right? So that's why the actual malice standard gives that sort of leeway that you don't have to be such a, 100% precise, to the T. But good point. Yeah, Adam, go ahead.
I guess I'm just kind of curious as to, obviously we're in a very weird time, with the internet, and kind of where this stops and where this continues. And I'm not here to debate what's true, what's false, but i.e., like, let's say like QAnon, okay? I believe that many of those people that are on there probably truly believe some of this, some of the crazier stuff on that end.
Yeah.
So I guess the standard, let's say the Clintons drink the blood of kids, okay? If they actually believe that, are we then saying that actual, and posting and writing about it, is that actual malice standard not met because they are in true belief, even, let's say, without that? I'm just curious.
Let me give an example. It's a little more live. So if you don't know what QAnon is, please, for the love of God, don't Google it. Just you don't want to go there. But let's talk about the election fraud issue. So in the aftermath of the election, there was a company called Dominion, which manufactured a lot of the election equipment, right? They make the machines that count the votes. A number of people, prominent people, argued that Dominion's equipment was fraudulent and it was designed to flip votes from Trump to Biden. And some people even alleged that it was, Venezuela and China, God knows, I don't know what the hell it is anymore, right? But foreign countries were hacking and using doing things to alter the outcome of the election, right? Insanity, right? Just lunacy, right? You can hold an opinion, but if it's verifiably false, it's defamatory. A number of sort of right-wing networks like One American News and Newsmax actually had hosted these guests making these accusations, and they later put on a statement, which they basically read in front of a camera saying, we withdraw this. We do not agree with this. Dominion did not have these allegations. And the reason why is their lawyers were scared out of their minds of being sued for defamation. Dominion's now sued Rudy Giuliani, Sidney Powell, the MyPillow guy, Liddell, whatever his name is, and a few other people. And like they're seeking $1 billion in damages. B, not million, billion with a B. I would be scared out of my mind of that judgment because they continue repeating statements that are verifiably false, right? If your opinion is that Hillary Clinton drinks the blood of children at Comet Pizza in DC, just if you know what I'm talking about, just don't Google it, please. Right? That's not just an opinion. That's you're stating as a fact. It's not like I don't like Hillary because she has bad hair, right? That's an opinion. You're stating as a fact, and that's verifiably false. That's the reckless standard. You should know that Hillary Clinton's not drinking the blood of children at a pizzeria basement in Washington, D.C., right? You should know that the MyPillow guy, the MyPillow guy should know that whatever he's saying is not true. I mean, he might believe it, and people believe what they believe, but that's not much of defense. Anyway, that's all I want to do on MyPillow, and I don't have one of the pillows. I don't know what the guy's name is. He's a MyPillow guy. But I think those defamation cases will be huge. A couple of years ago when I taught this class, we had the Covington, Kentucky boys. Remember, these were these high school boys from a high school in Kentucky, and they were on the National Mall. And they got into this altercation with this Native American guy. And initially on social media, it looked like they were taunting this Indian dude, and it looked really bad. And a lot of media outlets were critical of them, saying that these are these entitled, privileged white boys, and they're taunting this Native American. And then it turned out when other video was released that, in fact, the other guy was messing with them, and the video was misleading. The boys sued the Washington Post, which I think settled for undisclosed amount because they were on the hook for liability, right? These were not public officials, public figures. They were just boys who just got caught up on Twitter, right? They were no one. The newspapers argue that they became public officials because of all the attention put upon them. That didn't work. So I think at least the Washington Post and maybe one of their outlets settled because they were afraid of a defamation claim. But this is a serious issue. I would not want to be Powell or Rudy or the other people now. They're going to be – the defamation lawyer is very good. I know him. He's a very good lawyer. He's going to destroy them. It's going to be – the discovery is going to be painful also. Anyway. Yeah, Anthony, I don't remember all the details because I taught this one a couple of years ago, but I know at least the Washington Post settled. And a lot of the reporters actually apologize. They put up tweets saying, "We apologize. We withdraw our statements. This is not true," and that sometimes can avoid a lawsuit. All right, what else? All right, the standard in Sullivan, this actual malice standard, only applied to public officials as elected officials. In later cases, which I've not assigned, the court extended it to public figures. So if you're a celebrity, same rule. If you're Julia Roberts or Tom Hanks or Oprah, whoever you are, right? You're a public figure. You can't sue for defamation unless you show actual malice. Later, the court would even say if it's a matter of public concern. So if you're speaking about some news story or something, you're shielded by the actual malice standard. Defamation law is very hard in this country, which is why the Covington case and I think the Dominion election case are going to be unique because they got him dead to right. I mean, this is just, I think they're on the hook for serious exposure. That's why Newsmax and the One American News Channel had to basically back off, say, nope, not going to do this anymore. we do not want, because look, if you're a news network and you have a guest making statements, you are endorsing those statements. Those are your statements. It's the same as the New York Times publishing the commercial from the MLK group, right? That's your speech. So you can't say, well, it's just a guest on my show. No, it doesn't work. That's your speech. I've been on cable news before where the other guests are saying some insane stuff. I'm like, oh God, do I pull the plug? Do I just pull my mic and run away? But it's not my show. But when you're the host, that you're stuck with that.
So would that be why most stations also always have the disclaimer at the beginning and end of the broadcast? So I have a radio show on Saturday mornings through KTSU, and they do the disclaimer before and after the show. that the views reflected by the host of One Voice don't reflect the views of the.
Yeah, I don't think that really matters. I think even with that state, I think it's one of those CYA statements, right? Cover your, what, but I don't think it actually it's not going to absolve you of liability. Marcus, if you go on the radio station and you start defaming people left and right, I don't think that statement helps them. Yeah, don't do that, by the way. But yeah, you know what I mean.
Yeah, I was planning on cussing people out, cussing every caller out this weekend. I don't know if I'm joking.
Yeah, you start defaming your law professor. Although I might be a public figure, I'm on Wikipedia, so I think that might be the measure.
I'm on Wikipedia.
Well, we are both public figures. We can curse each other out. Nothing's going to matter. All right. Thank you, Marcus. All right. Other questions on Sullivan. I am verified on Twitter. That was verified before 2017, which they put a hiatus on Twitter for some time. Allison, go ahead.
For the exam purposes, is it just the public figure here, or when actual actor or someone came, will we have to know the time period for that?
I didn't assign those cases, so I wouldn't go that detail. I would limit it to the case for the government official.
Okay, thank you.
Thank you. All right. God, to this class. We have the second case, which I'm going to have to lecture on. I'm sorry. A lot of you put in your minute polls, give us a full hour back. Yeah, I know. You're preaching to the choir, my friends. All right. So we have this second case, Snyder versus Phelps, which was a fairly recent case, about 10 years ago. These are awful people, the Westboro Baptist. I don't know if you remember, I don't know how old you all are, but when I was in college, they used to come around college campuses all the time. Some of you might remember this. There are other similar groups. And their message is very clear that the United States is a sinful nation. It tolerates gays and lesbians in the military. And that's why we have bad things happening in the world. This is their vision of the world. I can't say any more simply. They go to military funerals and they protest. But they protest in a very smart fashion. They don't actually go into the cemetery. They don't go into the church. This is not well known. They stand at a distance from the proceedings. And in fact, they call the police in advance, say, hey, we're coming to your town tomorrow. Can you please set us up a zone where we can protest? So basically, they're under police supervision, so they don't get the crap beat out of them, which it could happen. And they stand there with their awful signs, about 1,000 feet away from the cemetery or from the church. In this case, it isn't even clear that the family of Matthew Snyder saw the protesters. They saw it on the news later, but it's not clear they even saw the signs. They protested Matthew Snyder's funeral with signs saying, "You're going to hell. God hates you. Thank God for 9/11." Some just awful stuff. A lawsuit was brought under the Maryland law for the IIED, the intentional infliction of emotional distress, which I'm sure you studied in torts. After this case, that tort's kind of a dead letter. I don't know if this is not IIED. I don't know what the hell is. Right? This is pretty gruesome. So I mean, I'm sure there are other cases, but I think in today's society, that tort doesn't have much legs to run on. A jury awarded $7 million in damages for IIED. The court reversed 8-1. The Roberts Court, as we'll learn, is remarkably pro-free speech. These are not 5-4 cases. They're usually 8-1 or 7-2. And you'll find in recent cases the court has an agreement on free speech that doesn't have in any other area of the law. The conservatives and the court's liberals tend to agree on free speech. Justice Alito is the outlier. He dissents in all these cases. And I think he has a point here that I'll get to in a second that's actually quite good. Chief Justice Roberts, who I love so much, wrote the majority opinion. This actually is a good opinion. I think he did a good job with this one. But he said the signs at these protests were in matters of public concern: war, peace, gay rights, religion. Right? The viewpoints are awful, but the perspectives were on speech. this is what you might call content-based restriction. You're basically punishing people for the content of their speech, to connect it to our lecture from last week. The protests were not made in a trespassing fashion. They're made on sidewalks and public streets. And public streets are the quintessential area where people can speak freely. You might remember Chaplinsky was on the street giving remarks, but he got in trouble. That's why Chaplinsky is just not a good case anymore. It's just, there's so many reasons why I think it's bad law. The court says that any distress caused by the picketing was based on the content and viewpoint of the speech. There's no actual interference with the funeral. Because again, it's not clear the family even saw the protesters. They learned about them later on the TV broadcast. And then Roberts says, he cites Texas versus Johnson, the flag burning case. And he says, this is a very important line. If there is a bedrock principle underlying the First Amendment, it's that the government may not prohibit the expression of an idea simply because society finds the idea offensive or disagreeable. This is a sentence that refutes the sort of line that you can punish offensive speech. On this court, not going to happen. Maybe in a different court it would, but not with this court. So the mere fact that the speech offends the Snyder family is enough. I don't know what the IIED tort looks like after this case. Maybe your tort professors have a better sense than I do, but this is pretty egregious. I mean, this caused so much hurt in the heart of the Snyder family. Their son had just been killed in the war. He was a young guy, younger than all of you probably. And we have this judgment. So then we have the Alito dissent. And Alito says that our commitment to open debate doesn't give a license for this vicious assault on the family. Matthew Snyder is not a public figure. Alito acknowledges some of the speech was on matters of public concern, but not all of it was. So he says, why do we have to take this sort of, all-in-one approach? Why can't we say, all right, this part's in public concern, but this part's directed to Matthew Snyder's family, right? You're going to hell. Who is you? Snyder, right? It's pretty obvious that's who they're talking about. So Alito would have just chopped it up and said, okay, fine, this sign is not IIED, but this sign is IIED. And all these signs are on camera, right? There's not, the evidentiary record is very clear. They went to the spot, they held their signs up, they were quiet, they didn't say anything, and they left. So we know what happened. And then there's the business of this epic, which is a really important point. The majority, this is why John Roberts always drives me nuts. He does crap like this. There was a blog post written by the Westboro Baptist where they targeted Snyder's family. And they talked about the mom and the dad raising their son in such an awful fashion, putting him in the military. This was targeted at them. Now, why did the Chief Justice not consider this epic? This is why Roberts drives me nuts. In a footnote, he says, well, the lawyer didn't mention in his petition for certiorari, so we don't consider it. Come on, that's not the rule, right? It was in the trial record. So Roberts copped out, right? Instead of addressing the actual difficult thing, he laid down this very easy to understand rule that ignored the facts of the case. This is the sort of thing that he does all the time. The rest of the opinion is fine, but this part I avoid. It never sits well with me that you can just sort of ignore it. Then we'll get to in a second. But then in the end, Roberts acknowledges how hurtful the speech is, but the First Amendment shields the Westboro Baptist from liability. All right, Denver, go ahead. Sorry, hand was up.
Do you think it's because you wanted to avoid creating precedent for online?
Yeah, he did not want to touch the epic because it's a much harder issue because it was directed at the people. I mean, imagine we had a Supreme Court decision about putting crap on Facebook, trolling someone, and that could be causing IIED, right? Sending someone some direct messages that are really offensive stuff. The court did not want to do that, and so Roberts decided the case he wanted to decide, not the actual case. Cyberbullying, yeah, I mean, these are issues that, this was 2011, so almost a decade ago. The world was different. Now it's even worse. I mean, there was a case in Texas, actually, where you had a guy with epilepsy, And, with epilepsy, if you see bright flashing lights, it sort of puts you in a seizure. Someone sent someone a tweet with a flashing GIF to give him into seizure. So basically he was actually charged with assault for a tweet, or it was sending a direct message or something by sending a flashing image. So I could do an entire class on that, but I can't. All right.
Also, I thought, is there any precedent for like a public versus private IIED? I thought another good point that Alito made is because they're using the Larry Point case.
Yeah, he's not a public official at all, not a public figure at all. The public, that line from defamation doesn't apply for IIED, I don't think. So I don't think
that's what I was curious about, because Alito makes that point, and I thought that was a pretty good point.
All right. Macy writes, Roberts adds things that don't exist with his opinion, but doesn't want to something outside the petition. Yeah, Roberts does his own thing. I mean, if you have me for con law, I don't need to repeat myself, but just he's in his own world right now, and he just does whatever he thinks is right, and no one can stop him. The Church of Wells come by our undergraduates, yell at us, but we're all going to hell. The police asked him to leave. It was not fun. Yeah. I remember when I was in college, we had these people come around to campuses, and that's what they do. I was actually, I went to the Supreme Court the night before this case was argued, and I actually talked to, it wasn't a member of the Westboro Baptist, but it was another Seymour family, and he had brought his family, his 2 young children, to D.C., and just I talked to him for a few minutes, and they are committed to their cause. They believe we are a sinful nation, and it's his mission to go and spread this gospel. He was completely candid about it. I have the video. Maybe I'll show it next week if I have time, but probably not. All right. Questions before I wrap up. All right. The minute poll is running. Let me just give you 30 seconds. I'll let you go. The current Roberts Court, stretching back to the Warren Court, is very free speech protective. When tort law interacts with the First Amendment, generally the First Amendment prevails with slander, defamation, and with the IIED tort. So in almost any tort case where it's some sort of speech act, the First Amendment probably creates a shield to liability. Even things like cross-burning, they're shields for liability. I'm trying to convey to you is it's a very pro-free speech court, even in situations where the speech is not something you would ever want to have said to you. All right. All right, everyone. I'll be back for office hours in about 15 or 20 minutes. Thank you so much. I'm welcome to see you, and have a good week, and I'll see you on Monday. Thank you.